May it please
The
your worship.
Assam Act, Preamble, Section 3, bracket 12A, 1419.
I am grateful. So I have shown and I have demonstrated to my lords that Section 19 point, there is no question of exclusive unions because basically this warehousing was never exclusive, and I have independently demonstrated that other powers under Section 36 and Section 12 give ample authority to frame rules relating to warehousing. I have shown all those provisions.
Yes.
Now, very quickly, my lord, I'm conscious of the fact that to do it in a short while. So there are 6 judgments cited by Mr. Shah on 2 questions. One is on excess of the rule-making power. So his first contention as a matter of law was that there was no authority in law to make any rule at all. That revolves around Section 19. If Section 19 does not stand in the way, then of course this point does not survive. His contention really with excess of rule-making power was, if you take Section 19 as excluding the power under the statute for warehousing license, then obviously any rule made will be in excess of the statutory power because the sections of the Act will not permit any rules. That's the contention. To which I have already answered that by reasons of Section 12, etc., 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 there is no difficulty. There is ample authority, Section 12, Section 36, ample authority in the various sections, warehousing to be established. So the judgments which he has given for excess of authority, they really have no application, but I will just indicate one by one very quickly the judgments. So the first judgment is, my lord, on the excess of rule-making power, 2011 SCC Online, Delhi 3033. My learned friend has referred to paragraphs 32 and 33. And basically in paragraphs 32 and 33, there was a rule 6J5 which was contrary to Section 25 of the enactment. Paragraph 30, Section 25 of the Act protects consolidation of rights in the land, etc., etc. A new restriction is not permitted in the express stipulation in 25.
2011 Online, Delhi, page
3033. Paragraph 32 and 33. I'm not going to the details with the time consuming, but the basic point was a restriction or dilution of rights which is there in the rule is not permitted in view of the express stipulation in Section 25. So Section 25 prevents any rule in the nature of Rule 6J. So that was the fact of that case, my lord. Section 25 provides the rights after the land is allotted shall not undergo any change. However, under Rule 6J, nature of the right becomes non-transferable. So basically, you're putting a non-transferable condition in the rule which is not permitted under the statute. Those are the facts of that case, which naturally will be in excess of the power.
So there is no transgression of any power under the statute by this rule, right?
By in our case.
Yes.
Here there is.
Yes.
The cases which Mr. Shah has cited are all cases where there is a transgression of the statute. Either it goes beyond the statute or it goes contrary to the statute. Our case, there is nothing contrary to the statute or going beyond the statute. That's the basic distinction. There, my lord, 2003 SCC 40. One second, have I got that case? Let's take it out. Yes. Paragraph 8, 13 and 14. 2000, volume, year is 2003 SCC, page 40.
Not this one. It's 2003-4 SCC. It's page 40.
No, sorry, I'm sorry. Not
605.
2000
3-4 SCC 605.
695. 2003 4 SCC 6. Which one your lordship has got? 2005 SCC 451?
No, 2003-4 SCC 695.
Yes, that's on a different subject, my lord.
Okay.
If your lordship takes, just a moment, 2006 4 SCC 517. Lordship has it? Paragraph 29, if your lordship has that judgment. (2006) Volume 4 SC 517, paragraph 29. So in paragraph 29, this was a case where the statute required the hearing, but so you had to terminate an existing lease upon giving reasons. Paragraph 29. What they did, my lord, instead of terminating a specific lease, they brought out a circular for terminating all the leases, lock, stock and barrel, without giving any particular reason for terminating any lease. And the court held that the statute did not contemplate such a whole-scale cancellation of leases. So the rule or a circular, that part of rule which purports to terminate all the leases without notice, does not conform to the scheme of the Act. Paragraph 29, last paragraph. Because paragraph 29, end of the page at page 534 says, for a prohibits any order of termination without giving a hearing. So obviously, if the section says in the statute that you have to give a hearing, a rule which provides that you can terminate without a hearing will be in excess of the statutory power. So that really was the basis of this judgment. I'm just showing your lordship that these are very extreme cases where the statute says something and the rule says something contrary to the statute. Statute says has to be given, hearing has to be given for termination. Rule says scrap it wholesale, no need for any notice. So that's the sort of case. That is, my lord, 2006 4 SCC 517 at paragraph 29. Now, my lord, SCC 517. What are the other judgments on excessiveness? There is 2000 volume 5. No? So next judgment 2000 volume 5 SCC 451. Here my learned friend has referred to paragraph 14. Rule 63 in paragraph 14 was adversely affected, was held to be contrary to the provisions of the Land Reform Act. Paragraph 14. I'm not, for purposes of time, taking your lordship into all the facts. Same proposition. Again, contrary to. Now, the other judgment on the other principle now, which he has said, mentioning of one means excluding of the other. Just give your lordship those very quickly. First one would be, my lord, 89 to SCC. 465, yes. 1989, 2 SCC, 2 supplemental SCC 465.
But these cases would also fall under that.
No, this is a different principle. These cases are on section 19. He's saying that since, may I just remind your lordship?
No, that you can have special provisions for supply, sale, etc. of country liquor.
Yes, yes. That's right. It will cover the other point also. Yes, your lordship is absolutely right. With respect.
Which leads to the argument that you cannot have for foreign liquor.
That's right. I'm obliged. That's the argument which is made.
So, this rule is transgression of that power. And
yes.
So, these cases can also fit into that argument.
That's true. That's right. But he has given other examples very shortly. 89 supplemental 2 SCC 465, para 16. We have extracted 42 of the Act, Section 40, Rule 18. It will be clear that Section 42 envisages orders, preparation or confirmation, a scheme and reparation separately. Rule 18 provides a limitation only in respect of application under the section. The maximum expresso unius est exclusive ulterius, mention of one thing applies the exclusion of another. So that principle is there, paragraph 16, as applied in this judgment. So when mention is made only of orders, the implication is that preparation of confirmation of a scheme and repartition are excluded. Paragraph 16.
Yes.
Then, my lord, 2003 4 SCC, page 695. So regarding the formatting of different types of leases, one type of lease mentioned residential, other type did not. So the interpretation at paragraphs 4, 5 and 6. So he is saying that the lease contained in Appendix 11 shows that the terms are different from the lease in Appendix 13. Appendix 11 does not prohibit the lease. Appendix 11 prohibits the use of building for any purpose except residential. So para 6. The lease under the purported terms of lease is precluded from using the house for any other purpose. This interpretation further supported the phraseology of the relevant clause of Appendix 13, which contains no reference to residential. As a canon of interpretation, expresso unius, etc., what is expressly mentioned in one place but not another must be taken to have been omitted. Same principle. And he has also cited, my lord, yes, I'm not citing, maybe one or two more he has cited. So these are the basic principles. And my short answer to that is twofold. One is that since the various sections of the Assam Act, which I have shown your lordship, expressly confer the power, there is no room for any interpretation under 19 at all. And even if you go into 19, the question is, there is no exclusive privilege for warehousing even in 19. And we are concerned only with warehouses, nothing else. 19 itself shows that for country spirit, many warehouses are permitted under the rules. So the privilege, if any, is not for the warehouse, the privilege is only for the supplier, for supplying in one particular area. There was never any privilege for one warehouse to be allotted to any one zone. That was not even in 19. So the question, the application of that rule doesn't apply. My lord, may I proceed to the next question? Now, the next subject is, it has been, before that, my lord, one more question. Section 36(4) has been relied upon by Mr. Shah. So I have to deal with that. Get it from the relevant affidavit. The affidavit of the warehouse regarding. So kindly give me a moment. Take it out, brother. Take it out. That. Yes. So according to my learned friend, section 36(4), kindly see this. He has relied upon this. Power of the state government to make rules. I have placed all these. Then 36(4). Lordship has it?
Yes.
While framing rules under this act, the state government may provide from time to time reservations to be made in favor of persons belonging to scheduled caste, scheduled tribe, backward class, educated employed youths. So this is a rule for reservation for these selected categories, with particular reference to economic backwardness, and we may also provide for discouraging or preventing monopoly in matters relating to such licenses. Lordship sees the word preventing monopoly. So my learned friend says the section which is saying monopoly should be prevented, and this is exactly what has been violated in this case. First of all, this is only applicable in this subsection 4 is only applicable in the special case of reservations for these categories. This is not a section which applies to the general category at all. But more important than that, this section is not the law of Meghalaya. Kindly note. Lordship has this? Why is it not the law of Meghalaya? Because 36(4) was brought in, Lordship appreciates, the state of Meghalaya came into being around 72. And the law as prevailing in 72 in Assam was adopted by the state of Meghalaya. By the adoption order, kindly comes to the affidavit of, take it out, Ajay Kumar Agarwala, dated 4th October 2021. My lord, this is important because this statute, the date of the statute is important. 4th October 21, kindly comes. Central Bonded Warehouse.
Page in the manual?
The Lordship has it? 4th October 21?
Which page in the manual?
Which page? Yes. All right. Now, kindly starts with from page 26 onwards. Meghalaya adaptation of laws order. Yeah, may I? I'm sorry. My learned junior is right. Your Lordship has this manual?
Yes.
Please take the manual first before coming to this. Manual makes it very clear. This is, of course, the details. Kindly take the manual. Section 36(4) from the manual, if your Lordship kindly comes to. Page 30. Yes. Lordship has it? Comments. Subsection 3 and 4 have been inserted by Assam Act 11 of 1974. Kindly note the date. And subsection 5 has been inserted by Assam Amendment Act of 73, coming to force at the date of the Principal Act. In section of subsection 5 was necessitated, required to cancel, etc., past orders. So this is the comments. Now kindly come to Assam Amendment Act of 1973. Kindly notice subsection 3 and 4. Assam Amendment Act of 1973 is after state of Meghalaya has come into being, and from 72 onwards, those further things done by the state of Assam are not relevant for the state of Meghalaya at all. Today, if state of Assam passes some law, amendment to this Excise Act, that will not apply to the state of Meghalaya. Only the law applicable to Meghalaya, the area known as Meghalaya, prior to the creation of Meghalaya was adopted by the adoption order. So kindly now come to page 26. of the affidavit. Lordship has it?
Yes. Ajay Kumar Agarwal.
Yes. Ajay Kumar Agarwal has annexed everything in detail. 4th October 21. Page 26. Lordship has page 26. My lord has it? Yes. So, whereas by section 79 of the Act of 1971 for the purpose of facilitating the application of any law in relation to Meghalaya state, government of the Meghalaya as the appropriate government is empowered to make such adaptations, modification of the law as may be necessary. Now, therefore, in exercise of the power, the government of the state of Meghalaya makes the following order. The crucial order. Meghalaya Adoption of Laws Order 1973. It shall be deemed to have come into force on 6th day of April 1973. As on from 6th day of April 73, the Shillong City So-and-so Act with amendments subjected to before, kindly note, with the amendments which it has been subjected to before the 21st day of January 1972. So, amendments up to January 1972. That's the cut-off date. Until repealed, etc., shall have effect. So, whatever was the law, the Shillong Courts Act, prior to 1972, 21st January 72, shall have effect. Then, next, Meghalaya Adoption of Laws Order 1973, Order number 3, page 27. This was really for civil courts. So, more page 27 is more important. So, 1973 order, appointed day, kindly see. The appointed day is 21st January 72. Existing law means law in force immediately before appointed day. That is before January 1972. Lordship sees it?
Yes.
And section 3. As and from the appointed day, that is January 72, existing laws and amendments which are time and shall until ordered have effect. So, up to January 72, whatever was the law in Assam will have effect in the state of Meghalaya, because that is the day I believe the state came into being. 21st January 1972 is the crucial day. And the Assam Act is listed at page 35. Assam Excise Act, I'm sorry.
So 36(4) would not apply.
Would not apply. I'll show your lordship. It comes now, kindly see page 47. Page 47.
Yes.
Very important. 18th March 1974. Much later. The following act of the Assam Assembly, which received the assent of the President, published 18th March 1974. Sorry, 15th March 1974. To amend the Assam Excise Act. Kindly note. Page 47. And on page 48, if you turn the page, this amendment has come in at subsection 4. Which is being relied on by my learned friend. Page 48. Absolutely clear. That scheduled caste, scheduled tribe monopoly provision, subsection 4, page 48. So, amendment, clause 2, subsection 4, Lordship has it. Page 48. So, from 47 and 48, it is clear this 36(4) came in March 74, and the adaptation of law, and no law in 74 of Assam can have any effect on the state of Meghalaya. So this, my lord, really does not require to be considered. Apart from the fact that on the face of it, not applicable to our case. Now, my lord, the next subject, which is very important matter, is the policy itself. Because my learned friends have argued strenuously that this policy has no identifiable rational reason behind it. It is a completely useless policy. It has no public purpose. It has no nexus with the act, and it's only a burden upon the supplier who has to pay more, and it will now go, either the supplier has to pay more or the customer has to pay, and it has no corresponding purpose at all except to harass them. More or less, this is the argument. Now, for that reason, I have to go to the for the challenge in their letter and the justification of the policy. If I may address your lordship on this point.
Yes.
So, of course, I'll come to the law later. The scope for judicial review in these policy matters in liquor is very, very limited. Very limited. I'll show those judgments. But let us go straight to the crux of the matter and let us see his first challenge. And that is interesting because we will see what was his challenge. Very limited. He has improved his case substantially later on. But I would respectfully submit that a liquor giant like this would have taken all proper legal advice before writing the letter. So anyway, let us come to, my lord, page 65. The challenge.
Page 65 of?
Of the, what, writ petition? Writ petition. The letter of 13th May 2021, which is his sheet anchor. Lordship would also take note of the well-known proposition that the initial challenge which is made is usually the real challenge. Now, what is there later on improved in affidavits is less consequence. So let us see his initial challenge. When I say initial, I mean prior to his writ petition where he has taken other grounds. Let us see what he says. And what is my response? So, kindly see May 13, 2021. After the rules have come into force, this is his letter, the attack. Lordship has page
Yes.
13th May. International is the representative body, first paragraph I will leave. We have for your reference, notification seeking creation of temporary antibiotics. Second paragraph I leave. Now let's come to the third paragraph. The notifications make no mention of the reasons that warrant the introduction of CBW in the supply chain. We can only assume there are valid reasons for creating such monopoly that will complicate and stretch the process and time for fulfilling consumer demand, apart from increasing cost of operations and logistics of supply. So, according to him, time will be stretched for fulfilling consumer demand and the cost and logistics. The private monopoly complicates the matter even further. It could easily tend towards abuse of CBW's dominant position with no perceivable government control. There have been instances in other states of the havoc and the loss of image that private monopolies have brought to the government in power. So basically, what he is saying is that it will affect the time for the consumer to get the goods, and the cost will go up, and the CBW may misuse its monopoly power. This is the sum and substance. There is no clarity of the services the CBW will provide and the benefits it will bring to the suppliers, to the government, or the consumers. It is only fair that the beneficiaries of the yet indeterminate services should pay for such services. to amplify. If the creation of CBW is for ease of government control on the supplies, then rightfully the margin should come out of government revenues. Alternatively, the introduction of the supply chain is to enhance consumer confidence, then it is only fair the consumer should pay for the cost of this by increase in the consumer prices. Well, it was rather an extraordinary submission that if the state government has a proper policy for improving its regulation, because regulation is one of the functions of the Excise Act, then he says you should pay from your own pocket. My lord, by this process, any regulatory measure should come from the pocket of the government. That's not the law. Creation of a monopoly is evident government oversight, etc. CBW margins, like for bonders, is undesirable move. State is seeking comparison of ex-bond prices in Meghalaya with those in contiguous states. You will appreciate that no other state has such stipulation. No other state does the trade margin as high as 17% that CBW representatives are seeking from industry players, and no commensurate services our members can perceive. So, 17% you are charging from us. I have already showed your lordship, this is completely wrong. That part I have already shown from the earlier affidavits. And that I am not getting any commensurate service. My lord, the purpose of an excise policy is not to provide services for some supplier staying in Haryana who is sending supplies to the state. That is not the purpose of the excise policy. Purpose of the excise policy is regulatory, my lord. So the question is the system being benefited, is the government being benefited, the public purpose? If the government is being benefited, it is the public purpose. I may not give extra services to the supplier. So, review the matter, clarity on the margins, allow for the additional cost to be absorbed by the government or to be passed on to the consumer. Putting the burden on the consumer is not only unfair. So, what is only challenge is the cost will go up. Please understand, Lordship will understand. Cost is going to go up. If the cost is going up even for a good purpose, either the consumer must pay or you must pay. Why should I bear additional cost? Sum and substance of the challenge. Lordship appreciates, it's very important, this letter. There is no constitutional challenge under section 19 that this is beyond your powers, excess of your statutory power. Nothing. The power to make the rule is not challenged. All this expresso unius section 19, you're beyond the statutory power, all this is not challenged. They are not throwing any challenge to the authority of the state to enact this rule. Nothing. Only challenge is, my cost is going to go up. CBW will be in a dominant position. They will extract 17%. Kindly appreciate. I have to only, this is all that has to be answered strictly apart this letter. 17% I have to pay. Maybe you have very good reasons, as it says. The creation is for ease of government control on supplies. So conceding that ease of government control on supplies, purpose is good. But if I have to pay extra, government should pay the money, or the consumer must pay. The only challenge to the creation of CBW. There is no other challenge. Private monopoly is not permissible in law. Discrimination being favored.
I don't know whether it's mentioned in the ground, but it was added to his submission, Mr. Shah's submission.
Yes.
That this commission would also add to the retail price.
Yes.
Which would depress the market.
Correct. I'll meet it. But where is that in this letter? It's not in the letter.
No.
I am only pointing out what's in the letter. Many arguments have been made which are not in this letter. That is, of course, there. I'll meet all the arguments which my learned friend has said. Price going up and all that. All that I'll meet. My learned friend has already indicated in this letter, my learned friend's client, that the price is already fixed. This is the maximum price fixed in the neighboring state is fixed. That's the upper limit. I'll show your lordship all that. But in this letter, question is, if it's a genuine challenge, like genuine challenge to the statutory power, will it not be in the letter that you have no authority under the law to make these rules? It's not there. Will it not be in the letter that you cannot create a private monopoly because the law prevents you? CBW is contrary to the law of creation of a private monopoly. It should have been there. None of these legal challenges are there. Only commercial challenge, 17%. and take it from the customer or take it from yourself. That's it. Now, whether I have to, first question I put to myself, my lord, if this is the basis of the challenge and I have shown your lordship that 17% in fact was not charged,
Zero.
the whole thing falls to the ground in view of the subsequent facts, ultimately zero. So zero is to be shared between the government and the consumer. Zero, we are happy to share zero. Zero is zero. If he is paying 17% more than he was paying earlier, and he can talk and say, well, a bonded warehouse, I was only giving 8%, now I'm giving them 8% and another 5%. So bonded warehouse, extra 5%, where will that come? Maybe you should take some of it, consumer should take. But if it is zero, where is the argument remaining? He has not incurred the extra cost. The whole thing falls to the ground. First question. There's no rebuttal of this in the affidavit. So zero is zero. Zero has to be shared between the consumer and the government. Well, meaningless. But this is the only challenge I'm showing your lordship. Now, we have replied to this and we have given various reasons why we have done this. Kindly come to page 70 and 70 onwards. So his challenge essentially that I am having to cough up extra money has already fallen to the ground on the material before your lordship. Now why I need it, I am indicating. Before I start indicating, your lordship will appreciate that even if some reasons are given, it is not really, I'll come to those principles, the court has to give the benefit of the doubt to these policy provisions unless they're completely absurd. For example, completely absurd, many examples have given by Mr. Paul when he was arguing. I will give you one example of what sort of policy can be struck down. If, my lord, I know this is getting a little close to reality. If, my lord, the state of Meghalaya today says every building in the state of Meghalaya should be colored blue and white, then your lordship will strike it down, because blue and white has no connection with the objects of the Municipal Act. And one High Court actually did it, of course. Your lordship knows better. Blue and white was struck down by one High Court of India. I need not elaborate. So I just give you a lighter way and an example of what sort of thing is struck down. But if I give some reasons which are possible for justifying a bonded warehouse, central bonded warehouse, then normally the law is, there is no great scrutiny of that, provided it is possible. Now, may I give you the reasons? Kindly come to paragraph 5 at page 71. Paragraph 5, paragraph 10, paragraph 11, paragraph 12. These are the immediate response. It is observed that some bonded warehouses applied for a lesser number of import permits, perhaps due to financial constraints, as the investment increased manifold after introduction of prepaid ad valorem duty, since most of the liquor companies would not dispatch and accept indents less than a truckload of the projects. All the bonded warehouses are indenting goods individually, and to make up for the number of truckloads, they tend to order slow-moving brands, leading to unnecessary piling of stock, which becomes unwholesome, unfit for consumption, ultimately having to be destroyed in due time, causing losses to both the bonded warehouse and the state exchequer. May I explain this, my lord? Lordship, if I may give an example. My lord, let us assume, now, I am a small bonded warehouse somewhere in the north of Sikkim. My customer, the retail shop in that town which is close by, that shop wants 10 crates of, let us say, Old Monk rum, for example. Now, he has to contact the supplier of Old Monk rum, wherever he is in North India, Haryana, Punjab, wherever. Now, that man will not send, for him to make sense, he has to send one full truckload to the bonded warehouse. Lordship appreciates. For 5 crates, he will not do it. Only when 10 bonded warehouses all over order enough Old Monk rum for him to make it worthwhile to send one truckload, then that truckload will go. So, this bonded warehouse will have to wait. He cannot get what he wants immediately. Now, under the new law, what has happened? Under the rules, every registered brand, like Old Monk is a registered brand, the CBW has to maintain 1 full month stock for the entire state. So today, my lord, any bonded warehouse can ask for even a small quantity. And that will come from the CBW to him. It doesn't have to come from the supplier. Therefore, he says that they were not accepting dispatch less than truckload. Now you don't need a truckload because you will get it from the CBW. CBW has got the entire stock. So even if you want 5 crates, you can get it. So this is reason number 1. I'll show your lordship that this has been supported by various letters of the warehouses themselves. Now reason number 2. With the introduction of the bonded warehouse, any bonded warehouse will be able to indent any brand as per the requirement, which will result in minimizing the investment with the assured turnover. Since central bonded warehouse will be able to supply an assorted range of products in a single truck, which otherwise had to be procured truck-wise from the different companies. Kindly see Roman 2. No, this is very important. This is supported by letters of the various bonded warehouses also.
Yes.
So, any one brand which would normally have to wait for a full truck can now be indented from the CBW. So, small quantities, 10 different brands I can get from CBW. Now, otherwise, I will have to write for those 10 brands to 10 different suppliers who will give it to me when the truckload is full. Lordship appreciates. That is what is said in subparagraph 2. Kindly note the reason given. Roman 2, paragraph 5. Lordship kindly makes a note because these are the reasons for this policy. And I rely heavily on the reasons for this policy, and I will show your Lordship that the warehouses, individual warehouses, have supported this reasoning also. I'll come to that. Then, my lord, number 3 is equally important. With the introduction of CBW, it will be easier for the government to exercise control and monitor one entity in place of existing 45 bonded warehouse, and it serves as a single point of collection of duties, etc. levied by the government, thus helping in plugging the revenue leakage. So, may I explain this?
Yes.
There are 45 bonded warehouses all over the state. Now, how does revenue leakage happen? Revenue leakage happens in this fashion. It's not a question, as Mr. Paul had argued, that nowadays, before getting the excise permit, you have to pay, before getting the necessary permits, you have to pay the entire excise duty to the government. Only before that can you proceed further. That is true. Now, my lord, assume a challan is coming into the bonded warehouse. So, there are documents there which reflect the number of bottles. Now, how does the leakage occur? The challan reflects 1,000 bottles, but actually 1,200 bottles enter the warehouse. Say some bonded warehouse, because of many possibilities, usually some collusion between the bonded warehouse person and the supplier and the truck. So what happens? 200 extra bottles comes, it's absorbed into the warehouse and it is sold off in the black market or it custody, whatever happens. So 200 bottles of leakage of revenue of excise duty goes, not reflected on the paper. For that, my lord, we have excise inspectors to stop this. Now, one excise inspector may be for 2 bonded warehouses, 1 bonded warehouse, 3 bonded warehouses. But now I have to monitor 45 bonded warehouses. There is bound to be some leakage somewhere. Now, today, that same entire liquor of this outstation comes into one CBW. I have 4 inspectors there. They are monitoring full time all entry of liquor into the CBW. Therefore, the question of revenue leakage becomes much less. I'm monitoring one place. I have to guard one place, not 45. I have to check one place and not 45. So the revenue leakage is here. Single point. That is ground number 3. And as a result, for this and otherwise, the policy, the revenue is going up. After CBW has been created, total revenue has gone up. I'll come to that, my lord. Now, before I proceed further, may I show your lordship the CBW affidavit, where those letters are there. September 23. Kindly come to 13 September 23 of the whereas CBW affidavit. The counsel for the bonded warehouses, who is supporting the supplier, could not rebut any of these points that better stock availability, less time, because transportation time has also gone down. Now the transportation time is only from CBW to the retailer, or chipsies. CBW to the bonded warehouse within Meghalaya. Earlier the transport cost was from Haryana to the bonded warehouse. So now the cost has also gone down. Kindly comes to, Lordship has this affidavit, man? Of dated 13 September 23. Kindly comes to page 34 onwards, my lord. I'd like to place a few of these letters which are important. In the days when the central bounded warehouse was, of course, supporting us.
He is still there.
You are still there for this purpose.
Only for this purpose. Madam.
Only once more. Again in a lighter way. You're all in a lighter way.
Absolutely on the right.
Right. They have to support us, my lord, on this, because if the policy goes, all warehouses go, then 1, 2, 10 hardly matters, my lord. Anyway, page 34. So the bonded warehouses, it's not only I who am saying this, it is the CBW and the bonded warehouses themselves who have acknowledged this. Kindly comes to page 34. Lordship has it? Yes. With reference to subject above, that is Umfolio Central Warehouse, we like to state this: after inception of this central warehouse, we're extremely happy with the functioning and service provided by them. We are able to get the goods on time as per our requirements, and availability of the goods in our bond has become much easier as compared to earlier. Kindly note. Next, page 35. We are satisfied, etc., etc. Availability of brands, terms of goods provided, and availability of brands, because availability has gone up. The investment of our bonded warehouse has been reducing a lot, and sales of our bonded warehouse increased by 40 to 50%. Lordship sees, page 35. The sales will increase because, kindly sees, if now I can get the goods much more quickly, they don't have to wait for a truckload, then the sales will increase because the sales will go, the retail shop will get them much faster. Page 35. By the body warehouse. 35. Then Lordship comes to page 36. These are all different bonded warehouses. We're happy with we get goods timely, and availability of brands is much more prior to the central warehouse. Same thing has been said. Page 37. I hope we'll continue to strive and keep away unnecessary supply shortages in future. So they are also saying that this demand and supply is doing well. Page 37. Then we are, similar is page 40. Page 40, your Lordship has notes, kindly knows. Timely supply of all brands of liquor. None of these letters have been contradicted. No, there is no suggestion that there's anything wrong with these letters. Now page 41 is the last letter and most important. I intend to place this letter in detail because this gives all the reasons from the bonded warehouse point of view. Kindly permit me to place this letter. This is a complete clarification of the state policy and how it has benefited the bonded warehouses and the state also. Kindly see page 41. Lordship has page 41.
Commissioner of Central Exercise. To Commissioner.
Yes,
84.
yes. OS bonded, yes. I'm grateful. The benefits as we as the bond have reaped and are enjoying after introduction of CBW are numerous and a few of such benefits as under. Kindly see 1, 2, 3, 4, 5, 6, etc. 1. A bond is not paying excise duty, import pass fee, transport pass fee and literage fee in the excise department. All these are being paid by CBW. By virtue of this, our bond is saving time, documentation as well as money. Ground number 1. 2. Lordship has it?
Yes.
Our bond was dealing with so many supplying companies, more than 40 suppliers, and was negotiating with all these suppliers one-to-one regarding supplies, payments, etc. Now we deal with only CBW. This has saved us considerable time. Saved time is utilized in other business ventures. Now 3. 3 is very important, which is recorded in our letter. Now we can order to CBW in small quantities, and that too of many brands and categories according to our requirements and market demand. Previously, we had to order full truckload of many brands which are slow moving to particular supplier. In old times, we were supposed to block working capital for such slow moving brands. Introduction of CBW has reduced our working capital requirements. This is a great saving for us. So that same truckload argument which is there in the state is being repeated here. Then number 4, we are previously selling goods on credit basis to retail wine shops. With the introduction of CBW, liquor business moving from credit system to cash and carry. This is immensely benefiting our bond in the short term as well in the long term. 5. Brand portfolio has increased in the warehouse due to possibility of ordering small quantities of any brand registered in Meghalaya. It's helping our bond to increase sales volume with the same stroke reduce working capital. 6. Since the supplier is only CBW 1 located in Meghalaya, location advantage, the goods are supplied to a warehouse in short span of time, etc. So if earlier he was getting it from Punjab, Haryana, wherever at the time, now he has to get it only from the CBW. In Meghalaya. 7. Previously no fixed margin for bonded warehouse. Now our bond is getting 8%, ensuring profitability. So this is by the statute, this 8%. 8. Supposed to place order with the company procuring permits. Then they used to intimate the bottling, entire process time consuming. A new scheme, we are placing orders on CBW without visiting excise department. Kindly note. 8. 9, 10, same thing, obligated to full truck, even if the brand is not fast moving, now there's only one supplier. So the entire reasoning of the bonded warehouse, how they are benefiting, has come in here. So this is one of the policy reasons at page 41. Now the other policy reason which was given to your lordship is plugging revenue leakage. I explain. I'll substantiate that with our additional affidavit. Kindly comes to that.
Miscellaneous case number 30.
Miss case number 13 of 2025. Lordship kindly takes that document. Miss case 13 of 2025. So, if your lordship comes first to 168, the revenue leakage. Kindly comes to page 166 on the subject of revenue leakage, page 166. Why it is necessary also. 166 your lordship has? Report of the Controller and Auditor General. 166. Oh, he hasn't given the document, is it? Miss case 13.
Miss case 13. Yes.
Miss case 13, page 166.
Yes.
Report of the Controller and Auditor General. For March 18, this came into effect, CBW, 20, right?
20 the notification, 21.
20 was the notification, 21 was the CBW. This is in March 18, just before that. So what does the CAG say? Kindly comes to page 168.
But Mr. Banerjee, just an observation.
Yes.
We have to adjudge the rule by reading it on the face of it.
Absolutely.
By literal or by ascertaining the intention. But
If the intention, I tell you, Lordship, why? I'll show that.
whatever
The result.
correspondence is there prior or after or any kind of negotiation would not be very relevant.
I tell your Lordship why I'm showing it. Because the courts have held, I'll show your Lordship, that if there is in the case of liquor, in case of this very company, that if the intention is to stop revenue leakage, that is a bona fide reason. Your Lordship is right that whether revenue leakage actually has been stopped or not is not maybe a ground for adjudging the validity of the rule, if that is what is falling for your Lordship. But the fact is that it has been noted that the state is saying that there was a problem of revenue leakage, because why was this done? My learned friends are throwing a challenge to the policy, not to the rule only. That there was no policy reason for creating the warehouse. In that context, not on the rule. The rule is a different argument. They are saying, why was this warehouse created? So the reason given, one of the reason is revenue leakage. So CAG has said that there is a lot of bonded warehouse revenue leakage of so many crores. That is at page 168. For that purpose. Not for the rule purpose. Lordship is right. For the rule challenge, no correspondence matters. Your Lordship is absolutely right. But when you are talking about purpose of the notification having no purpose.
Because the prayer is that this particular amendment is void and ultra-vires the statute.
No, for that I'm not showing this, my lord.
Yes, which you've dealt with.
That I've said it.
Section 19.
That's a different argument. This is to show there was a problem of revenue leakage, and one of the reasons for the policy was to plug the revenue leakage, which I've shown your Lordship in the letter. So page 168 shows CAG report that the bonded warehouse, not monitoring it, is costing revenue of 3.86 crores. Evasion of excise, page 168. This was one of the mischief which was required to be addressed by having a CBW, is the pluggage of revenue leakage. So that is a policy reason at page 168. That's the reason for this. I'm showing this. Not for the rule. And also, I'm showing at the same document, page 165. Or should I show para 5 instead?
Yeah.
Which one? 165. 165, your Lordship, also comes. 2018, the CAG says that there is a lot of evasion of revenue at the bonded warehouse. And 165, your Lordship sees number 3, Roman 1, Roman 2, Roman 3, taxes on commodities and services, under the head state excise. Lordship has it? State excise from 2018 onwards, 22,000, 27,000, 37,000, 30,000 in 2021 is the COVID time, then goes out to 36,000, 43,000, 66,000. So revenue has gone up sharply right through. Revenue is going up because of our policy and otherwise revenue is going up. And leakage is come down. That's our contention. Now what, do you want to show the judgments?
That's why I'm looking at the judgment.
Mr.
Now-
Banerjee, there is another matter we have.
Yeah, very well. Man. Tomorrow?
Can we continue tomorrow? Along with that, your PIL.
That PIL. Man. I'm grateful. Your Lordship has been very patient. Man. I'm trying to make it as concise as possible. I'm not repeating a single point.
You'll be able to conclude tomorrow, Mr.
No,
Banerjee.
I will not. I have a few more points. I'll try my best as fast as possible.
Yes, but start preparing your notes and complete
I will. I'm
complete
doing
it
that
the
already.
next day.
I'm doing that already.
Please
I'm
come.
covering a lot of points in a short while.
Yes, but
I think I'm doing going a little faster than Mr. Shah was going. Mr. Shah is making objectionable noises. He's not
No,
happy.
no, my microphone is switched off. I couldn't have made any noise.
Anyway,
Not to.
I'm grateful. I'm grateful.
it's not faster or slower, Mr. Banerjee, but what substance at what.
That's fair. Entirely for your Lordships to judge.
You.
Mr. Shah has made many pertinent points, my lord. I have to attempt to answer some of them in my own way.
But tomorrow and one day more, please finish it.
I'll see, my lord, what I can do.
You
I have to. There are also a lot of judgments cited by him on
You-
monopoly and other things. I'll see what I can. How short I can.
marshal
make.
all your precise skills of
I shall try my best.
finish it off. with the notes.
Grateful.
And Mr. Shah also, and who else will speak?
I'm in connected matter, my lord. The state has two matters, so I'm responding to the
Miss-
second invitation.
So, Mr. So you'll be adopting most of.
Most of the argument, but I will be supplementing some of the arguments after the argument of Mr. Banerjee is over.
And thereafter you will.
Thereafter, my lord.
And there you will be on reply.
He
Mr.
joined
Shah.
it.
Yes, my lord. I'll try to be as brief as possible.
Factual letters were read against us, my lord. So allow us to, my lord, because my lord had suddenly, my lord, asked Mr. Devalji to not to respond to any of the letters, but Mr. Shah not only relied upon or made some allegations against
No, I
us
was
how we
thinking,
stated
so it's kind of become kind of a march against time. So is no use of just hearing the matter and abandoning it and
it.
going
Or
away.
scuttling us, my lord, would deprive us from responding.
No scuttling. But then you see, we were also taught that if there is paucity of time, you have to abridge, compress your
Keep
argument.
it compressed, my lord, but this matter is going on 2021, my lord.
It may be going on, but then you have to put your entire substance in the least possible
Yes,
time.
absolutely, my lord.
Do no justice, do injustice to your client, but please do justice to us also, so that we can deliver the judgment. And
Right. All I pray is, my
Right.
lord, the
there is
case, my lord, we
no
can't,
no use. Otherwise, think of the wasted, colossal wasted expenditure.
We would not do that, my lord.
Yes,
Grateful.
it's only
My lord
request
will give us sufficient time to respond also.
request in that direction.
I am so grateful. So grateful.
Yes.
Sufficient time to respond and judgment not delivered. What you will do? Responding. Sufficient. Again, you are going on repeating. Sufficient time to
No, I will
respond.
not repeat, my lord. There is no question of repeating anything.
You whatever is your argument, you have to put it shortly, succinctly, and so that everything is in. And please attribute some intelligence to the judge also,
Absolutely, my lord.
that he does not need a hammer, bum 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 bum
Not
to
at all,
hammer.
that is not my intention.
All right. So hope to conclude and deliver
Absolutely,
judgment before
absolutely.
5th September.
Grateful. Grateful.
Tomorrow.
Item number 1.
Excuse me. এখন লিস্ট এখন বানানো
अच्छा इटू इसको निकालो तो इटू लिमिटेशन का दोनों निकालो क्यों रखो लिमिटेशन का एक बड़ा किताब है बिग बुक बाइंडिंग
Your Lordship has requested us to furnish the list. We have compiled the list. We have furnished a copy to my learned friend also. So that it becomes, it's only about the dates, man.
दादा उनको भी हमारा एक कॉपी उनको दे देगा ना लेकिन स्पेयर तो नहीं होना तो कोर्ट में दूरी देना पड़ेगा ना Lordship, from our end, we also made out a list as your Lordship directed yesterday. Oh, they have got short.
What is your start date? 18/1/2011.
Yes, Lordship. Two copies, sir. Two. Hey, এখন দিদি না মই আপনার দিদি জেরক্স করি নাই মহারাজ খালি দুখনে কৰিছে নাই মহারাজ নাই এক কপিও নাই কোনখন আপোনাৰখন নাই নাই কৰা নাই না only 2 copies এটাতো নাই নহয় মোৰ লাগিল লেঠা নহয় আছে মোৰ এখন হেল্প दुकान ले आई गलती क्या है ना अच्छा हो जाएगा itu kita तो 55 देखो ये देखने से क्या फायदा होगा मैं समझता नहीं what they are doing. हाँ ये भी दे देंगे जब शुरू होगा तब देगा আর এখন দিন আপু তো এই মানুষ আপনি কোন अच्छा इसको इसको ये निकाला तो पैराग्राफ इसमें F2 चीज इसमें से पैराग्राफ में देखो प्लेंट मेमो मेमो में देखो तो कौन पैराग्राफ में हम लोग पहला में जाओ बॉडी ऑफ द पिटीशन में जाओ हम लोग 18 का पीछे क्या किया अभी 18:6 18:1 हमारा हमारा जो उसमें मिलेगा क्या हाँ इसमें हम लोग देखो अब इसमें हम लोग बोला है इन सूट में काम है देखो 70 एनेक्चर 13 हम पैराग्राफ ऑफ शॉर्टनेस है 13 हम पैराग्राफ ऑफ शॉर्टनेस उसको रखो तेज कर अच्छा ठीक है क्या देख रहे हैं
Pre-mediation period is exempted. Excluded.
Yeah, no, mediation period is exempted. Because your lordship will see the mediation was filed on 16/8/2020. From there, then report came on 21/2022. This period is also excluded. Then money shoot was filed after 60 days of the receipt of the mediation report, my lord. Mediation period has to be excluded, my lord.
Lordship, if I am allowed, I am like to submit another written submission, what I am ready to do today.
Earlier you have filed, sir.
Today I am filing again because Honorable Lordship has
Then you take back one, otherwise that will create confusion.
confused.
Yes.
All right,
You-
I may kindly be allowed to refer my submission only, Lordship.
No, you take back the first one and put in the second one.
Okay, Lordship. So let me be allowed to start.
You have already long started. Now try
Not
to
yet.
finish.
I have not completed lot yet.
You have not
The
even started.
viable part of the impugned order, I have not. As soon as I touch it, Lordship will find where is the defect lies. Now, if we go, Lordship, if I'm allowed to proceed, Lordship,
No,
if we
always allow.
go to the judgment,
No, if you kindly follow his chart, first deal with the chart, then do whatever you like.
now, all right, Lordship, I will come that position. But till now, we have not touched the impunity what has happened in the hand of the learned trial court below. As soon as your Lordship's attention goes, your Lordship's vision will change.
No, we
Of
can't
looking
change
into the matter.
We can't change the period of limitation. We can't rewrite limitation, Mr.
No, that is
Chaudhary.
not there, Lordship.
We cannot. Whatever may be the infirmity in the judgment, we do not make any observation regarding that. But if it is barred, it is barred. And if it is barred, the merits are gone.
Lordship, I
You know,
may
so-
kindly be just refer the matter that the judgment which we have annexed here I have made in my submission that the Honorable Supreme Court had directed to assess the remaining period of balance in hand as on 3/10/2021. But the learned trial court below assessed my remaining period on 15/3/2020. Kindly see, that is the perverse finding by the learned trial court and assessed that I had 4 months, 21 days. It is not a fact as per. So there lies the, Lordship, the mistake. Otherwise, had this, my position of the remaining period of balance in hand on 3/10/2021, then my position would have, as I have submitted, that we have filed the case appeal 2 months, 4 days ahead. Now, if we do not go, Lordship, to that fact, all this we are unnecessarily, my learned, your counsel is leading your lordships to a different branch of the.
No.
Yes, I am sure.
Your lordship will kindly appreciate. I am not interfering, my brother. The Supreme Court order says the entire COVID period plus the greater period. He is asking for the entire COVID period plus 90 days. I am saying that you take the entire COVID period and you take 144 days.
No.
Higher than 90
Lordship,
days.
my
Then also it doesn't go.
learned senior counsel is making
Kindly,
mistake.
sir,
No.
kindly look into my chart.
Please
If
see.
I'm wrong in my chart, you tell me.
For what purpose the plaintiff or the appellant is aggrieved and has come before the Honorable Court? The appellant FCI has come that actually the learned court is to assess the position on 3/10.
Let us see the Supreme Court judgment where
But-
they say
Yes, ma'am.
90
Page
days.
147.
Kindly.
147, 11 is at 140. 140.
140, Lordship.
Of the supplementary paper book. Main paper book.
And my petition is 140.
Yes.
Memo of,
No, supplementary, sir.
no, supplementary, I am going on the original one.
The supplementary 140 is the paper book. Your lordship will
All
find
right, that
clause
is your
3.
reference. That is your reference, sir.
No, this is yours, sir.
All right. Same.
Same.
Same. 140.
Clause 3, your lordship will see. In cases where the limitation would have expired during the period from 15/3/2020 till 17/8/2020. Here, my lord, the limitation expired on 5/8/2020, that is within this period.
No, go to point 2.
3.
No, go to point 2 first. Consequently, the balance period of limitation remaining as on 3/10/2021, if any, shall become available with effect from 1/3/2022.
That means, sir,
Please let me complete, sir.
sir, you have got 2
My
days.
here
Simple
is my crux of my entire case here.
It's simple
My friend.
arithmetic, you-
Why simple? Where this position to be 3/10/2021. The learned court below has assessed my position on 15/3/2020.
No.
Well, yes. You go through the judgment.
You, sir, kindly refer to my list of dates. If you
Your
don't
list
agree-
of dates, I am not concerned here, sir. I am
You-
concerned with the Honorable Court's or trial court's order. It is available, Lordship, at the first page of the memo of appeal, and we have enclosed it for our reference at page number 200 and at the back 213, Lordship. The learned court, Lordship, in page number 219 has discussed the actual direction of the Honorable Supreme Court, but in the last page made a mistake. Therefore, the period of 3/5/2020 to 28/2/2022 stands excluded for the purpose of limitation. The order of the Honorable Apex Court has further clarified, in case where the limitation would have expired during the period between 15/3/2020 till 28/2/2022, notwithstanding actual balance of period of limitation remaining, all persons shall have a limitation period of 90 days with effect from 1/3/2022. In the event of actual balance of period of limitation remaining with effect from 1/3/2023 is greater than 90 days, that no longer period shall apply. The plaintiff have balance limitation period 4 months 21 days on 15/3/2020. Kindly see. Whereas the learned court is to find out as on 3/10/2021. Thus, there is a mistake.
My lord,
About 1 year some period was there at the time of 15/3/2020.
your lordship, I'll request kindly allow me to refer to these dates. My learned friend will look into the dates. If your lordship finds that the dates are wrong, your lordship will interrupt me. Your lordship will-
Sir, please
You
bear
are
with me.
sir, you-
Since yesterday, I am making and trying to impress upon the Honorable Court that my case is guided by Article 55. Kindly see.
We are not disputing
No,
on
no,
it, sir.
no.
We are not disputing
But how
section
you are calculating that? Why I should explain? You are asking the Honorable Court that please insist upon from Mr. Chaudhary that why he has not filed the case from 18/1/2022 to up to the status quo order.
Sir, kindly refer to
I am
my
not
list of-
concerned.
This
My-
is in your favor only. I am referring to.
That I know. Yesterday when you have referred section 15, that is also in my favor. How can you take advantage of these legal positions?
It's mathematics, sir.
Mathematics not, this is arithmetic.
This is all about arithmetic, sir.
Also
calculation.
arithmetic, but why you need this? Because my span is 3 years.
Your lordship will kindly see, sir. Your lordship has seen for last 2 days we are going nowhere. Your lordship will
Because of
kindly-
your
Your
lordship, because of
will
my
kindly
learned
see.
senior
This is-
friends zigzag position of submission.
No,
Go according to my. Please go according to
Yes, yes.
my original synopsis of argument.
Yes, I'll go. Your lordship will kindly see. I have
That
calculated.
I am unable to complete that my submission. Your lordship, my friend is not allowing me to complete the position. If I complete,
No, you will complete, but kindly, sir, look into the list of dates that I have
Why your list of dates is needed?
Mr. Konwar, please take your seat. Let him finish.
Let me finish, sir. Kindly allow me.
I was.
Here I am.
No interstate argument. Please carry on.
Lordship, till yesterday, when my learned friend was trying to seek explanation from the appellant's end that why I have not, or the plaintiff has not filed when the cause of action had arisen of 18/1/2011 till the date of
You are now
injunction or
you are
status
now
order
put
passed.
to Mr. Chaudhary. We are putting you to specifics. No kind of evaluation of any finding in the judgment or assessment of any action taken is permitted. You have to go strictly by the facts,
Yes.
dates, and show that your suit is within limits.
Yes, Lordship.
That's all. Only date wise, nothing
Lordship,
else.
if I am allowed to, page number 12, no?
Yes.
Of my memo of appeal or the paper book, volume 1. No?
Page number 2.
Oh, yes. Yes, yes, Lordship. Page number 12, Lordship, of the paper book, main paper book. And my argument, I prepare first one synopsis with reference to that, Lordship.
Where is that? Give whichever notes of submissions you are relying upon, give us.
I have not understood, followed, Lordship.
Have you prepared any written notes?
Yes, yes, I have already submitted on the first day. That is of dated, although it is dated 22nd August 2024, but I've submitted it on the, when Honorable Court started formally.
Yes.
Kindly see the synopsis of submission by R. Chaudhary, advocate for this such and such. I have not to go on all these things, Lordship. I'm going only that when I filed the petition, I mean the commercial money suit for compensation, the other side filed their written statement and also filed an application under 7 Rule Order 7 Rule 11D that the suit is barred by limitation. So the Honorable Trial Court asked me to give show cause. I have given show cause. Hearing was there, and the order was rendered on 13/12/2023 that the suit is barred by limitation. That is only the contention, Lordship. I'll come, sir. I'll come, please. Now, if I go to my page number 2 of my submission, that the fact of the case in hand is that for the failure of the defaulted transport and handling contractor Sri Ranli Lindor, now deceased, the general manager FCI at Shillong invoked clause 10C of the model tender form, in short MTF, whereby the general manager NAFR Shillong under the said clause 10C, annexure 1, relevant page is 55, summary termination, issued a letter on 21/9/2010 addressed to the contractor informing that the FCI without terminating the existing contract would go for appointing contractor on ad hoc basis at the risk and cost to get the contractual work done for the remaining period as he has abandoned the contract. The failed contractor, upon receipt of the letter dated 21/9/2010, went before the Honorable High Court of Honorable Guwahati High Court Shillong bench by such and such and obtained a stay order by order dated 21/9/2010, by order dated 28/9/2010, the Honorable High Court and the said petition was disposed of at the stage of admission hearing on 19/10/2010 and dismissed the writ petition being a contractual matter having disputed question of law. That after the appellant, by its order dated 18/1/2011, annexure 13 at relevant page available, page number 74, had terminated the contract as per clause 10B of the MTF, annexure 1, relevant page 55, with immediate effect to get the remaining work done for the remaining period at the risk and cost of the failed contractor now deceased, and had started the process of appointing contractors on ad hoc basis, issued the first letter of demand, letter dated 28/5/2011, annexure 1014 at page 75, making a claim for him to deposit extra additional expenditure 67,46,718 incurred by the FCI and also subsequently. Now, the failed contractor then filed a civil suit on 1/8/2011. Now we find, Lordship, on which date the case was filed. 1/8/2011 before the learned assistant to the Deputy Commissioner Shillong by TS number 26 of 2011, new number is 212 T of 2013, and Miss Case 63, new number is such and such, for an ad interim injunction by which obtained order dated 22nd/8/2011 and by order dated 29/8/2011 to maintain status quo till the suit is finally decided. No demand letter could be issued for subsequent loss because of the status quo order dated 29/8/2011 till the main suit is disposed of. The Shoko's reply and the written statement were filed, and after long gap, upon hearing the parties, learned trial court rejected the injunction petition by its order dated 7/3/2018, and the status quo order dated 29/8/2011 got vacated automatically, annexure 18 at page number 79. That the status quo order was vacated as above stated after long 6 years, 6 months, 8 days, because the cause of action to realize the final amount that could be calculated at the end of 2 years contractual period by 3/6/2012 had shifted from 17/1/2014 with 3 years fresh limitation having been merged in the total time period of 6 years, 6 months, 8 days consumed due to different reasons to vacate the status quo order dated 29/8/2011 with by order dated 7/3/2018 accordingly, according to law as provided under section 14 of the Limitation Act 1963 and shifted to 8/3/2018. I mean, this is the first shift, Lordship, and I have referred the Honorable Supreme Court's order as reported in 1994 Supreme Court 2329, where the Supreme Court said that when a case is in that way is arrested limitation, the aggrieved party will get a concession all this time spent. Next period of limitation for 3 years.
Before you come to that,
Yes, Lordship.
you come to paragraph 6.
Paragraph 6, Lordship. Okay.
So we assume that your cause of action arose on 18/1/2011.
Lordship. My yesterday, Lordship, I was very humbly submitting
Now,
that we had to take.
no, please, let us go step by step.
Okay, sir.
18/1/2011. And your cause of action for filing a suit.
Lordship.
And in this kind of a suit, your time is 3 years.
Lordship.
All right.
Lordship.
Now, please come to your paragraph, the second subparagraph of 6. 1/8/2011, you file the suit.
Paragraph number
Same paragraph, subparagraph, next subparagraph.
Sapira. Okay.
1/8/2011.
Yes, Lordship.
Now,
Now the failed contractor, I think it started with that.
1/8/2011.
Yes.
Now, please ask your junior to calculate
That we have calculated, Lordship. We have given.
how many days?
This is 200. That is 200. इसको कहाँ तक मिला है? Up to that. 1,095 days.
Suit was filed on 1/8/2011.
Please, Mr. Pawar, please sit down.
Lordship, the cause of action we have given in our list of days,
No, Mr.
calculation.
Chaudhary, please, a simple class 2 question, 1/8/2011 minus
Yes, Lordship.
8/1/2011.
Yes, Lordship.
We used to do it in class 5, 6. Now they are doing it in class 1. The physics we used to study in class 8, they are now studying in class 5.
Understood,
you
Lordship. My friend has calculated in that way, is given in the morning, that we have calculated 18/1/2011 cause of action, 3 years limitation
Again,
would have
you are
ended
going-
on such and such date.
1st August 2011 minus 18/1/2011. What is the number of days difference?
1st
So
August
18,
2011.
18 to rest of January should be 13,
196 days will be precise, madam.
196 days.
196 days. And if your lordship takes the status quo order date, it will be 216 days.
260. We have gone, Lordship, to that extent. Now my humble submission is this.
No, it is all right. We are not, we are stopping here 196 days.
Yes, Lordship.
After 196 days, you have
We've got
Filed
the status quo
no,
restriction.
you filed a suit. You filed a suit.
We filed the suit long after that, Lordship, after crossing the
1/8
hurdles.
2011. That is 196 days from the start of the cause of action.
We have filed our suit on 21/3/2023, Lordship.
No.
We have not filed because we are not the in the trial court. Today is the date again fixed for that. That is 212 of 2013.
No, Mr. Kowar, this is right or wrong? The cause of action, alleged cause of action 18/1/2011.
Yes.
They filed the suit 1/8/2011.
No, that first suit was filed by us. We got the status quo order on 22/8/2011. So
No.
from the date of status quo till the vacation of the status quo, 7/3/2018, this 2389 has to be excluded in terms of Section 15 of the Limitation Act because injunction was
No,
operated.
whether you filed or he filed.
Yes, same.
This time runs from the
yes.
start of cause of action.
Yes.
That
Filed
is-
by them, Lordship.
let it be, but there is nothing by you.
We could not do, Lordship, file.
So what? You,
Because we could not do, Lordship, because yesterday I submitted that our matter is a contractual matter. We are to, after termination, we have to give him notice that you have to pay the cost and then we will submit the bill that
Whenever
demand
you-
that.
you-
These are our contract. We cannot, we are a public sector undertaking and dealing with food channel, food movement
why
of
can't
food,
you
Lordship.
please?
We had to, when there was not
whenever you have filed the suit, whenever you have filed the suit, you are taking a benefit of this injunction order in their suit or not?
Lordship, yes.
All right. When
Yes,
you are
sir.
taking the benefit of the injunction order in their suit,
Lordship.
you have to start from the date of start of cause of action
Yes, sir.
till the date of filing of your
Yes,
suit
Lordship.
and deduct the period of continuance
Yes, sir.
of the order of injunction 15 subsection 1, which I showed, which we
Now
discussed
that is, we have
yesterday.
explained on page
Now
number
to
7.
enable our calculation, that period from start of cause of action to filing of their suit, all right, will be the period deducted from the start date again in 2018, whatever, to file a suit.
Yes.
Because that period has already run. You have not filed anything, they have filed a suit after so many days.
They have filed because of to check us so that we do not enforce our demand notice as per the contract, Lordship. There is a difference between our position is we are doing the public utility services, movement of food from railway siding to up to Juai. So we became very busy for taking requisitioning the truck, etc., because food is a mandate of public, Lordship.
Can you forget their filing a suit? Please try to think in this way. Start date 18/1/2011.
Yes.
Filing of suit 2018. Let us assume that the order of injunction has fallen from the sky.
Yes.
2011 to 2018. Now from 2011 to 18, you have to calculate the whole period, start
Yes,
of cause of
Lordship, we have
action,
calculated.
and then minus period of injunction.
2018 से कितना दिन आता है देखो.
We have
Please,
done.
please agree on
2018
this is going on end of
Yeah, yes, ma'am. That's why I was, your lordship will kindly see the chart for me.
No, we will finish it on the
Yes,
next day.
It is coming, Lordship, 2,379 days. We have given our calculation.
Yes.
And plus 2 leap year dates. Because my learned senior friend is asking as if it is an application under section 5. No. I do not agree, Lordship. My long experience in this profession.
Okay,
we
please.
know that whenever any client appears to us, comes to us, what is
Please agree on a date, Mr.
time
Chaudhary.
period? 3 years gone, man. I cannot do anything.
We
so
have-
3 years, we are not to explain day to day. It is only to be explained in case of when any appeal to be filed or any revision to be filed. Then every date is to be. I will refer your lordship on Supreme Court's ruling I have come with today. That we are not to explain all these things.
My lord,
Because
today-
no litigant gains by going to court at a late stage. He is not benefited.
I am very sorry to observe, Mr. Chaudhary,
Lordship.
that you are thoroughly and fully confused.
I have not understood.
You have to go by the dates, nothing else. You are trying to explain, not he. Simple, 2011 cause of action.
We have given lordship
Yes,
2,379 days.
yes. And exclusion is that period of injunction, nothing else. Then the COVID period. Then the allowance the Supreme
Yes,
Court has
lordship.
given.
Lordship, I am giving calculation.
Then-
Totally we got 2,379 days.
I refuse to believe on that on such elementary principles of law, such a large amount of time will be taken. I am very perplexed.
No, lordship, we are abiding by your lordship's direction.
No, what is this? With
have
your
given our calculation,
with your seniority, it should be 1 minute's understanding. Either it is there or there. If Food Corporation has not filed it, they have filed it from some. They have not filed it out of some other considerations.
No, lordship, we have no other consideration, lordship.
You maybe
We cannot
may or
have
may
any
not
other
be.
with their public sector
They have
undertaking,
not filed a suit. They have not filed a suit. Finished within the period of limitation. But then why take up this court's time unnecessarily?
No, lordship, I am explaining, lordship, page number 7 I have given,
It's
lordship.
certainly not section 5. It is only dates. This date. Am I within 3 years or not? Then there is exclusion period.
Lordship,
Yes,
lordship,
please.
2,300 days.
My lord, he is not willing to listen to me, then how
Yeah,
can I?
what-
Let my learned friend kindly be allowed, lordship. He let me complete his. Then I will get my.
he will complete. Please choose a date.
Please.
I have proposed him 18th of August. He has said that 18th
No,
of
18th August is very far away. Please do it before that.
Let me check, my lord.
We have heard both learned counsel at length. Full stop. It is high time that hearing of this appeal on a very short point is concluded. Full stop. List this appeal for final hearing on
8, my lord, subject to your lordship's convenience. I'm here on 18 for another case, my lord. So that's why I was proposing. He has said that he doesn't have any objection because it's a Monday. I can come on Sunday, my lord. Because Independence Day will be there on 15th August.
Why don't you make it on the 7th?
My lord.
7th, Thursday.
7th, my
7th
lord,
of
I had
August.
in another court. That's why I'm not taking 7th.
18th, you have another matter here.
Yes, my lord. Inshallah.
Mr. Chaudhary, 18th is all right.
Yes.
Lordship, I have not come with the diary. And any way I will accommodate lordship's day today.
No, you are based mainly in
I'm based at Shillong, lordship.
based in Shillong. Okay.
Yes, lordship.
Then
So, lordship, on the 18th, may I be kindly allowed to just say something, and then my learned senior may start it, because I am not getting satisfied.
Your
because
lordship has given him 3
that
days.
If I cannot satisfy, I am not doing justice to my client, lordship. Kindly allow me that, so that I just apprise something.
18th
I have
August.
understood your lordship's mind now.
You sit in your chamber and you think for 1 hour, then it will become completely clear. Only the dates are important. 11, whenever it is filed, period of injunction, that period will be excluded. COVID period, Supreme Court
Yes,
order.
yes, Lordship. I'll give a perfect, because yesterday we didn't get time, Lordship.
Plus minus, plus minus, plus minus, within time or
Yes,
outside time.
we'll make a chart, Lordship.
There is no need of chart, just plus minus. All right, you can make your chart with a pencil also.
Yes.
That within time or outside time. That's
Yesterday
all.
we could not get sufficient time, Lordship. Therefore, somehow we have just raised.
There is no question of section 5, no question of sufficient cause, explanation, nothing. It's just dates.
We'll do it, Lordship. Certainly, I will do it.
Thank you.
We are
Much appreciated.